This is the first ever Zoom MIPLC Lecture Series event. We're very, very, very happy that João Pedro Quintais, who is a senior lecturer and postdoctoral researcher at the Institute for Information Law at the University of Amsterdam, agreed to do this. It's, as I was saying, it's particularly special because he's an alumnus. He's a frequent speaker at our MIPLC alumni conference, and I hope to have him one day as a lecturer, as a faculty member of MIPLC. His research focuses on matters relating to intellectual property law, particularly intermediary liability, content moderation, and the regulation of new technologies. And I've been following his academic career very closely, mostly because I learn a lot by reading all of his stuff, and also because we have shared interests. And I've noticed that he's branching out into the regulation of new technologies, and he's growing as an academic, and that is really cool to see. Tonight, he is going to give us a talk on Article 17. I'm the director of the Digital Single
Copyright in the
Market.
Digital Single Market Direct.
Exactly, they always have such charming names. Article 17 and the new EU rules on content sharing platforms. As I said before, Joao's going to give his presentation. At the end, I'm going to open the floor, the chat function, to have your questions. He's going to speak for approximately 40 minutes, and then I'll be taking your questions and articulating them out loud. I'll just be reading them out loud to Joao following his talk. We hope that this works. You've been muted, and I won't be unmuting you, unfortunately, but we hope you have a good time watching us chit-chat. So without further ado, Joao.
Thank you very much. So let me just try to do the sharing of the presentation. I know this is always a challenge, but let me see if I can do this well. Your screen probably, or my screen, just goes black for a few seconds usually. Hopefully not more than those. And I would just set, if you could give me a verbal communication that the only thing that we're watching is the first slide. Perfect.
Got it.
Okay, hello everyone. I'm doing that thing of actually minimizing all the faces, but I'm really happy to see that we have so many people here, and I'm really happy also for the invitation. So we're trying this out a little bit to see how it works. Usually we love to have more interaction, but we'll try that through the Zoom function, or those with privileged access can always call in. So before I explain what I will be talking about today, which you can see on this slide, some two disclosures. Firstly, a very important disclosure for me is that, as Seth mentioned, there is the little princess has just arrived from the kindergarten, and we're hitting the time where she's going to go to bed. I've just been informed that she didn't sleep today, so expect to hear some background noises, and I hope you're okay with that. Maybe you even get to meet her. And the second point that's particularly important here, because these are always really, let's call it complicated debates, is the fact that everyone has an opinion and everyone is a stakeholder in this debate. I just want to make sure that what I'm coming from here is, as I come from academia, and trying to give you the most neutral and informed academic view on this topic. Of course, I have my normative preferences. I'll try to make them clear as we go, but it's really important to stress this because this is really such a politicized debate that it is important to mention it from the outset. Now, let me just see where we are here. Okay. What I'm going to cover today, hopefully in around 30 to 40 minutes, is how we got here. And that's quite a large part, because without understanding the legal and policy background, you really cannot really understand the legal issues, I feel. The mechanics of Article 17, and then I'll touch on three topics very quickly on the definition of online content sharing service providers as a separate topic that probably should be seriously thought about and addressed in national implementations, the issue of authorization, and the issue of preventive measures versus user rights or freedoms. Now, I have published in all of these. I'll try to point out to some of that work, but I also try to point out to the opinions of others in this point. Now, I also should mention I've done a few webinars in the last month, so for those of you that attended the previous ones, just feel free to get up now, have a beer, and come back in about 15 minutes, because you've probably seen this part of the show before, or a variation of it. especially my colleagues at some of the projects I'm working on. On that note, I should mention I'm not just working on the Institute for Information Law. We are also doing research on Article 17 as part of a project for Recreating Europe, an Horizon 2020 funded project. And at least one of my colleagues, Sebastian Schwemmer, I saw is already here. And others like Thomas Ries, Christine Katzenbach, and Peter Mazet are also involved in it. So it's important to mention their names here because some of these insights come from our joint work. Now, how did we get here? As I said before, when I've done this variation of this presentation, there's a short story and there's a long story. And within the long story, there's different chapters. The short story is really about lobbying and politics. I always like this image of Axel Voss giving the thumbs up. He's the rapporteur for the Legal Affairs Committee. And there is really a strong emphasis on how this showed, for those of us believing in legislative intent as a method of interpretation, or maybe we should take a step back from that and understand that a lot of this is political compromise. Not that there's anything per se wrong with that, but it is the case that a lot of this legislation in particular, parts of it move through by the force of lobbying in politics rather than by the force of evidence-based reform. Now, longer story is perhaps more interesting, and it has to do with how the law was before, and how did we get here through changes in the law, especially legal interpretation. Now, in the copyright law chapter of this story that I'll be mostly focusing about, I think it's useful to think about it from the perspective of narratives. There is two competing narratives. On the one side, on two extremes of the spectrum. On the one side, you have this discussion about value gap, or this argument that there is a value gap in the online world that needs to be solved. On the other side, the more civil society side, you have this idea that this type of legislation that's been proposed will actually institute automated censorship through the imposition of so-called upload filters. And we'll get to see a little bit what that conversation is about. Now, and obviously I have to include the mandatory meme here about how the EU is moving away from the free and open internet towards a more controlled and censored internet. But I think the key aspect of this is actually explained very well by this image from the EFPI, representatives of the music industry. They're focusing on certain user upload content platforms, and they say they've become the largest on-demand music services, but do not pay creators fairly. And then the key example is always YouTube. YouTube, part of Google, pays less than X per user per year, and in contrast, Spotify pays 18 times that figure. And the gulf between this value that is exploited by the platform, in this case YouTube, which is always the example that is given, even now in the national legislation proposals for implementation, is always YouTube is the key example. This gap between what creators get, but in fact who's making this argument is most of the industry, and what the platforms pay is huge, and that is the so-called value gap. And the best way I find to explain the pre-existing rules here, or the rules existing at this time before the directive comes to force, is to ask whether we're actually here comparing apples and oranges and changing the law on that basis. The orange being YouTube and the apple, obviously, Spotify. So let's start with the analysis of Spotify. Spotify is what we might call an online music provider. It has this it works, let me just move a little bit here, the perils of using Zoom. It basically intermediates between copyright holders and the public, but the legal rules applying to Spotify are a little bit more complicated. This is a simplification, but Spotify on the right of copyright holders have to aggregate authors' rights, record producers' rights, and performers' rights. In some cases, they have to go to CMOs. In other cases, the rights are actually aggregated in record producers. The rights that they need to clear are usually reproduction and communication to the public in Articles 20 of the InfoSoc Directive. These are rights in the so-called sphere of primary or direct liability. And there's also a regime that might apply to a part of the rights aggregation on the copyright holder side, which is a multi-territorial license regime of the Collective Rights Management Directive, the CRM Directive. So this is more or less the legal regime or the rules in a simplification that would apply to an online music provider such as Spotify. Now the question is, are those the same rules that apply to YouTube? Because if we're comparing values, then we should be comparing the same thing and not different things. And in fact, the situation with YouTube is much different. We're talking about a user upload or user-generated content platform that intermediates between the public and the users. And what happens here is that the end user uploads copyright relevant content to the platform. usually this upload, not just Article 3, can also involve reproduction, but usually what's engaged here is the right of communication to the public with the upload, and that is regulated at the level of primary liability, which is more or less harmonized. So we have rights and exceptions and limitations in the InfoSoc Directive, and rules on enforcement, both in Article 8 of the InfoSoc Directive and in the Enforcement Directive. What you have also on the side of the platform, the regulation of platforms in this case was at the so-called level of secondary liability, which is mostly unharmonized at EU law level. And for these types of platforms, we call them hosting platforms. And their regime, the relevant regime here, is predominantly in Articles 14 on hosting service providers and 15 on the ban on general monitoring of the e-commerce directive. And the regime there is basically a notice and take down regime that says, well, these platforms, they're only liable if they know or should have known that the content that they host uploaded by users is illegal. And the moment they get knowledge, if they take down the content, remove the content in the language of the law, remove or disable access, then they are not liable anymore. They are still subject to injunctions as third parties, but the injunction is directed at mostly removing the content, and there's space in the law for duties of care. Under this umbrella of duties of care in these rules, many of these platforms, or especially the big ones, have developed so-called content recognition technologies, CRTs, and the quintessential example is YouTube's Content ID. Now, of course, there is more or less of a line between primary liability and secondary liability that divides the legal treatment of these players. Of course, an artificial line, but it exists there. And above that line, the way that copyright holders deal with user-generated content platforms is not only through these rules I just explained, but also through using those rules to get some licensing and monetization deals, get some ad revenue, that's what you see in a lot of these platforms, but also acting as trusted notifiers or flaggers, meaning that they can go into the system and actually provide within the scope of the content recognition technologies information and actually largely influence what content is taken down by the platforms. So this is the regime that we had in the books, so to speak, and as it evolved through court interpretation. What really changed is that through the interpretation of Article 3 of the InfoSoc Directive and also of the e-commerce directive, but mostly I would say on the InfoSoc Directive from my perspective, the scope of the right of communication broadened. And what happens is that the CJEU, Court of Justice of the European Union, started to erode these liability lines, with starting in cases already in Svensson, but most strongly in the GS Media Playboy case, and then going down all to the Pirate Bay Ziggo case, where it basically says a number of activities that usually wouldn't be considered communication to the public are now clearly communication to the public, and linking is covered, provision of link Cody box with pre-installed links is covered, and the operation of a platform, piracy platform such as the Pirate Bay itself is directly communicated to the public. And in red there, you see 3 other pending cases or the court that will further shape the scope. So one argument here is that the law is already slowly moving towards the erosion of these liability lines, but in a case-by-case basis with specific rules tailored to the specific player at issue here. Now, this is a long line of cases we could spend here discussing, but we're not going to do that. So this is the general gist of it. Where are we today then in the copyright chapter? Now, I will explain the provision later on, but basically the provision was adapted, and then what in Article 1710, it is said that for certain elements of the provision, rights holders and platforms have to discuss, with the assistance of the Commission, have to be part of stakeholder dialogues. Also other stakeholders are for the Commission to provide some sort of guidelines in order to try to understand how the complex provisions within Article 17 and those rules should be best implemented. So far we've had 6 before the pandemic really hit Europe. The 7th has been postponed. Mostly it has been a sort of a expected failure because there are many stakeholders there and most of them defend their position and just repeat it like they're repeating a sound recording. But for example, I was last Friday in a panel with the head of the copyright unit, and he informed us publicly that the EC is actually, the European Commission is coming with guidelines for public consultation, probably even later this week or next week. So there's some news for you for those that didn't know it. Now, at the national level, we have a lot of countries in so-called public consultation mode, and some of them have draft implementation bills. I'll discuss a few of them later on. There's also a boom of academic publications. I'll just point here that I was involved in drafting, and some people that are also here in the audience are signatories to these recommendations of European academics signed by 60 European academics working in this area. There's also the European Copyright Society that came with specific comments by Axel Metzger and Martin Senfleben on Article 17. So I'd recommend reading those. And there's a literature boom starting with many, actually already good literature coming out and good scholarship, but there's also a lot of stakeholder statements from civil society, NGOs, collecting societies, tech organizations, and others that are not purely academic societies like the LIE. And all of them, kind of what you see is, apart from, I would say, the academics that are trying to find kind of a more neutral playing ground for interpretation according to obviously their normative preferences, you see a lot of these different organizations pulling and pushing and tugging towards the position that they're representing. So quite a lot of work cut out for the Commission in this respect. If you want to know more, I just want to give a shout out to both the CREATE, Comunia, and also our project Horizon 2020, because they both are aggregating information in this respect and helping the transparency also of the national implementation processes. So for those of you wanting to be informed as lawyers or as researchers, these are really great tools to follow. Now, there's also a broader chapter of the story, and here I get to shout out to Sebastian that inspired me in a presentation that we did together to come up with a timeline that would layer on top of the collective of the CDSM directive, the copyright directive, the evolution at the European level. Now, I don't want to go a lot into detail in this because it's not the topic today, but we must understand that this does not happen out of nowhere. What we see, I think, is a concerted effort on part of the European Commission and at European level, at the policy level, of a push towards, let's call it, responsibilization of platforms. We see this move in different areas, but in the European Union, you see it mostly from a communication, since a communication from 2017 on tackling illegal content online, and then a recommendation on the following year with more or less the same topic, where you see an encouragement of corrective measures against illegal content. And illegal content is defined as any information not in compliance with union law or of member state concern. But importantly, when you look at the specific focus, it puts in the same bag or in the same bucket things that are quite different. And especially there's a huge focus on terrorist content. There's some references to hate speech, child sexual abuse material, and then all of a sudden, out of nowhere, you see IPR infringements and consumer protection. So I think it's important to understand that IP was also put into this bucket a little bit, I would say, with some, I would have some normative problems in actually including them in the same bucket. And this matters why? Because actually the CDSM directive, the copyright directive, had already been proposed before, and it changed significantly. You see it here. I don't know if you can see my cursor, but it changed significantly over the legislative process, highly contested. And by the time it's approved, it actually includes what many people consider upload filtering provisions, those types of proactive measures. And it sets a sort of standard. And what you can learn from this, if you think about the level that's north of the line here, what you can see from this is that actually you can think of it, I think of it as a sort of Trojan horse on information law policy. It establishes a sort of baseline that can be then used to go to something like terrorist content and say, well, this is much more serious. So if this is acceptable for copyright, then a much more stricter type of regulation on platforms would be admissible for others. And this matters because we are now entering the revision of the e-commerce directive, which is the horizontal regulation of online platforms, I would say, in Europe, and through the so-called Digital Services Act, which is just open for public consultation. So we will see, we're already seeing some efforts to state as a baseline what was decided in the copyright directive. And this is quite dangerous because by no means is the regulation of the copyright directive particularly protective of freedom of expression, as we'll see. It really depends on how it will be implemented. Now, this was the very long background, but I think it will be helpful are we good? Can you hear me well?
I can hear you well, and I just think it's time for those people who left for the beer to come back to the talk, right?
This is more or less it, yeah. Okay. Unless it's a really good beer in that case, and you can stay a little bit, 5 more minutes. So now I'll go briefly to the mechanics of Article 17, because it's really a complicated provision. So I'll just give you a bird's eye view, and then I'll focus on some particular issues. So again, let me try to move my Zoom control panel here. Who does it apply to? It applies to this horrible acronym of online content sharing service providers. I'll call them generally platforms when I can't say the acronym. Now, let me see. There is both a positive definition of the provision and there is a negative, an exclusionary definition. So it applies to UGC platforms, simply that host large amount of works that they organize and promote and that whose activity has a commercial and competitive effect. It's quite clear that it will apply to YouTube and other video sharing platforms. As we'll see, I'm now having doubts about whether it will apply to other major platforms such as social networks. And then there's a list of exclusions that's a sort of shopping list that more or less fits the criteria, but has to do with who will be the hardest. You know, Wikipedia, GitHub, Skype, eBay, and others made it clear to the Commission that you're actually, if you apply this, it will regulate us in a way that you're probably not interested in doing so. So they got an exclusion there. But what this means is that if you are excluded or if you do not fit the definition of UGC platform, you are a non-OSSSP platform. So you're an hosting provider that is not an OCSSP. And if you're an hosting provider that's not an OCSSP, you're outside the scope of the directive and you go back to the regime that I explained before. This is why it was important to explain it before. So if a major player does not fit into this definition, is actually going to fall back to the previous regime that's actually now going to be reviewed and reformed by the Digital Services Act. So quite a mess, as you can see already. If you're a lawyer especially, it's not an easy situation. Okay, now we've discussed who does it apply to a little bit, I'll come back to it. So the what and how, this then gets more complicated. If you are defined as an OCSSP, then the law basically changes and says you are communicating to the public. So no longer does this depend on knowledge of the legality of the upload. You're not secondarily liable, you're directly liable. It's like you're a copyright user in this particular scenario. The provision also clarifies that you are not benefiting from the hosting safe harbor, the notice and take down provisions I mentioned before in Article 14 of the e-commerce directive. And actually it says this is a carve out from the e-commerce directive. It's like specialis. Except if, so you're directly liable under this regime, you are an OCSSP, so you're communicating to the public, you'll be directly liable, except then it starts to really get interesting. Option 1, except if you obtain as a default an authorization from the rights holder, and we'll go back to understand what authorization means. That authorization, if you do obtain it, must cover the end user that uploads to the platform, but it will only cover that end user if his activities are non-commercial or commercial but without generating significant revenues, more or less if it's kind of priced into the license. We know this from some exceptions, compensated exceptions and limitations. I have to say this is going to be extremely complicated to determine. It's probably one of the many aspects that's going to go to the court. Now, if you cannot get this authorization, because let's face it, in a lot of cases, it will be impossible to get authorizations for everything that users uploads on the platform, then you go to option 2. It's a so-called liability exemption mechanism. Think of it as a new type of special safe harbor. This option 2 gets a little bit complicated too, because it says, well, you didn't get authorization, then you can only escape direct liability if first thing, and these are all cumulative requirements, you carry out best efforts to obtain authorization. Air quotes, these are real quotes actually. What is best, we have to understand these best efforts as a sort of, like Senfleman and Metzger say, expressions of the same duty that is imposed on the OCSSP. So basically you have to get an authorization, but actually what you need to prove is that you carried out best efforts to obtain an authorization as a condition to avoid liability. And some authors, and I like the ECS opinion, offer some options here, and they would say, look, if you're a big enough platform, you have to search for publicly non-copyright holders for that category of works that you host, like if you host music, you go to the CMO or you go to the majors, but if not for the other rights holders, you have a kind of notice, a more passive approach. I call it a notice in action to license, meaning if I get a notice from a rights holder that the content is there, I have to obtain a license, or at least I have to immediately remove it or then filter it. We'll see that. And also they suggest implementing a regime of pre-contractual obligations. Here we can discuss it further later if you want, because otherwise we get too much into the weeds. But this is the first logic, okay. First condition, best efforts to obtain an authorization, already vague and difficult to interpret. Okay, but there are other conditions. In addition to that, you have to prove or carry out best efforts to ensure unavailability of specific works for which copyright holders provided relevant and necessary information. This is the so-called upload filters provision. Or acted expeditiously subsequent to notice from the copyright holders to take down, so this is a notice and take down, infringing content, and make best efforts to prevent future upload of that content. So it's a notice and take down followed by a notice and stay down. And that's what the critics call re-upload filters. So if you can't get an authorization, this is the only way that you are not liable. But all of these, except the notice and take down, are cushioned under the guise of best efforts. So we'll have to define what these best efforts are. So pretty complicated, but I hope it's more or less clear up to now. Okay. If you are in this whole situation and that you have to apply these measures that are also called preventive measures, and I'll come back to those later, then the article understands, the drafters kind of understood, oh, this is quite one-sided here, so let's better include some sort of mitigation measures. And then so include rules on proportionality and assessment of several of the factors here. There's a mitigated regime for startup and small OCSSPs, which is mostly window dressing. I can address it later in the questions if you want why that is the case. Then there's a provision of on user rights or mandatory exceptions and limitations. Then because this was a carve out from the e-commerce directive, they had to introduce a new ban on general monitoring in Article 17.8. So saying that the platforms cannot do general monitoring, although they have to do this kind of filtering provision. And there's also safeguards, procedural safeguards for complaint and redress that go more or less hand in hand, but are not a substitute to user rights. I will particularly focus later on these user rights and safeguards that are mentioned here. Now, in sum, what we have, I like it very much, it seems a mix of the apple and the orange approach, a sort of legal hybrid. But I think what you have to take from the provision is a normative hierarchy. It is very clear when you read the provision, no matter what many people want to say, that you have licensing as a priority on one hand, like let's call it a corporization of the fundamental right to property and copyright, and on the other hand, the equivalent manifestation for freedom of expression and information, the user rights and freedoms. And then in both cases, the preventive measures are there, but they bend the knee, as my colleague Rossana Ducato says, for another matter, they bend the knee to the main provisions. So if we understand the rule under this normative hierarchy, it makes interpretation much more sensible and logic. But it's important to do this, because if you don't do this, you get to some of the results that national legislators are getting to. Now, very briefly, I want to talk about this definition of online content sharing service providers. This is kind of the elephant in the room. It's not really part of the stakeholder dialogues. It's not part, I think the Commission doesn't have competence to decide on it, but in fact, you're talking about best practice of cooperation to implement all these rules between, on the one hand, these platforms, and on the other hand, rights holders. But you have to know what these platforms are. And if you read Article 2.6 and the recital 62 and 63, what they suggest is this is more or less a case-by-case approach that has to take into consideration the factors that I mentioned, especially in the positive part of the definition. Why does this matter? This matters because if you think about organization and promotion and commercial competitive effect, but especially organization and promotion as key elements of the definition, you have to ask yourself, and some authors have made this point, do social networks fit this definition? And it's quite problematic because depending on where you put the required level organization and promotion, then you would either include these, and that means that's a huge revenue of licensing, but also a huge legal hammer to bring to social networks, especially Facebook, or you exclude them. Now, for example, if you read the ECS opinion, I'm doing the terrible thing of putting something up there on the slide and not really reading it for you, and some of you will be reading it, but I would advise you to read it. And on this point, and also Professor Séverine Dussolier in a forthcoming article in the Common Market Law Review makes this point, that if you take this seriously, then you would have to exclude, you could potentially exclude all of these online platforms like social networks that do not have very strongly structured, predefined options for promotion and access to content, very differently from YouTube, for example. So this is a kind of open question that I want to leave out there. We can discuss it always also, but it's quite important because are you then going to go to obtain an authorization on which basis? On the basis of this article or on the basis of the InfoSoc directive? All of this is extremely complicated, and most national laws will not deal with it because they'll just implement verbatim the definition. So I'm very curious to see how this is going to pan out. What I can guarantee is that if Facebook rejects this license, this is going to court, because CMOs for visual arts, for example, are very keen on getting these revenues from Facebook. Now, to the more tricky and thorny subject of authorization. So the article talks about authorization, but it doesn't say what type of authorization. It just exemplifies with licensing. There's a kind of a such as language there. And the main question, and this is part of research that in an article I'm writing with many of you know, or all of you, Martin Usuvec. So we have the working paper out there. What is the nature of the right in Article 17? We look at it and we come up with different interpretation options. And I'm going to just quickly run through them because, as you'll see, they are quite important. And it's not as simple, because if you read actually the provision, you see, at least in our view, 4 interpretation options. Now, the first interpretation option is that this is actually a subtype of communication to the public within the minimum standards of international law, especially the WCT. So it's very simple structure. Article 8 WCT talking about copyright, 3 InfoSoc directive is under Article 8, Article 17 is within it, we're all good. Well, this really doesn't work, because it's very clear from the legislative history and actually from the letter of the WCT that this was not meant for some of the activities that are provided by in this article. Otherwise, we wouldn't have secondary liability regimes all this time for these platforms. So it's not very clear that international law mandates this. Now, the second option is whether this is a subtype of communication to the public outside of international copyright law, but within the extended scope of Article 3 of the InfoSoc directive. This means that actually the EU standard has broadened itself through the cases that I mentioned before on hyperlinking and on piracy websites. And what happens is that scope is much broader now than the international minimum standard. And Article 17 would be fully within that new scope. Well, we can actually discuss this a little bit more, and there are several arguments why we don't think it's the case, but I think a really strong argument why this is not the case is also because this is being discussed right now in the cases in red that I put in the previous slide, whether that is even the case for YouTube. Now, if you further think about how this particular Article 17 is constructed, all the subconditions and elements that it has, unless you have a very benign interpretation of all of that and very I want to fit it within this particular shoe, it's not clear that this happens. So what we propose is actually that there are other ways of looking at this that are quite interesting. Is this actually a special right of communication to the public? Meaning that it's actually fully covered by what would previously be covered by Article 3 of the InfoSoc directive, meaning we can imagine that the court comes out and says, oh, these activities are covered, but because it is structured with such specificity and in such a particular way, it's actually a special right. And kind of the implications of this is because if it's a special right, then we'd have to discuss what type of licensing mechanisms are admissible to this special right, taking into consideration that certain rules that would apply to Article 3 of the InfoSoc directive might not apply to this special regime because it has its own specific sets of rules. The fourth option, and I know I'm going very quickly, but we can discuss this further if you want, is actually whether this is a new sui generis right of communication to the public. What we mean by this is actually, this is outside of the EU standard. This is something that was the realm of secondary liability, maybe partially overlapping with some of the scope, but mostly outside of the scope of the current interpretation of Article 3 of the InfoSoc directive. There are several elements for this, and part of them has to be with the definition of the particular platform here. There's a whole different logic in how you define the platform. And there is also a number of specific rules that would say for us, combining with the new cases that are out there, that this is not clearly the case, that it's within the scope of Article 3 of the InfoSoc directive. This leaves, as we'll see, a lot of freedom for member states to actually play around with the implementation. I'll get to that in a second. So in our view, and this is by no means consensual, I have to say this, but I have also, and I don't want to be arrogant here, I've read everything that's been written on Article on Article 17, I think, at least in English, Spanish, and Portuguese. And I haven't found a convincing argument why this is not the case yet. Actually, a lot of authors say, well, this is just a bad provision. Let's try to shoehorn it into Article 3, more or less. I think the new cases that come out from the courts, the 3 that I mentioned there, will clarify this a little bit more. I still don't see a way in which the court can entirely subsume Article 17 into 3 of the InfoSoc directive. Now, you might say, yeah, João, that's really cool, yeah, but does it really matter? Well, I propose that it actually does matter a little bit. Just check the time here. It matters because if Article 17 is a special or sui generis right, we can do a lot of different things with it. You know, one size does not fit all, but for certain fields, it would be possible to think about statutory licensing regimes or even mandatory collective rights management. If it's an exclusive right within Article 3 of the InfoSoc directive, then we're much more limited. It's direct licensing, which is not possible for a lot of areas. It's voluntary collective rights management, where we don't have pan-European solutions for this because there's no country of origin principle applies here fully, or multi-territorial licensing beyond specific rules in the CRM, Collective Rights Management Directive. And then we have this new regime of collective licensing with extended effect that is probably the best option, but we're currently carrying out a study for the Commission of these regimes in all member states, and it's quite a fragmented landscape. And there's some stringent requirements that would suggest that for some fields it might work. For others, we really have to do some sort of interpretation, gist of interpretations. And if any national lawmakers are listening to this, I would strongly recommend clarifying your Collective Rights Management National Act when you implement this provision to say that the existing mandates for communication to the public also cover this new right. Because if you don't do that, you might not have legitimacy to provide collective licenses in this field. So it's just as a matter of caution, I would really recommend that. Now, I will end on the point of preventive measures versus user rights or freedoms. Going back to the regime very quickly. If you don't get an authorization under Article 17.1, you have to comply with this best efforts obligation. So if you comply with this obligation, then you are allowed, you have to also comply cumulatively with the preventive measures in Article 17.4b and c. Now, it's not clear, if you look at national implementations and also the Commission, they always talk about multiple preventive measures, but actually, if you don't consider notice and take down of preventive measures or perhaps warning systems and others, mostly people are talking about content recognition technologies, filters and re-upload filters or notice and stay down. So this is what, for example, the word filtering in the national implementation of the national proposal in the Netherlands is mentioned 22 times, I think, and no other preventive measure is mentioned in explanatory memorandum. So the problem with filters is, however, that they're not suited to accommodate the user rights or mandatory exceptions in Article 17.7. And this is very well known. So I would just go check a recent post by Communia, Paul Keller at Communia, that on the basis of some research from TechDirt identifies 3 possibilities of filters fail, as they call them. But I think it was recognized in the stakeholders dialogue very clearly that at least filters are incapable of recognizing context. And if they're incapable of recognizing context, all of the exceptions that we have in Article 17.7 are actually, as you see there, are exceptions that cover transformative user-generated content and that they're contextual and dynamic, meaning not only they depend on the particular context, think of parody, quotation, caricature, pastiche, but they're also dynamic in the sense that they change their interpretation over time. And you have to multiply it by 27 member states with different understandings of some of these elements, even if they're considered autonomous concepts of EU law. Also, we learned from the stakeholders dialogue that AI is not going to save us. There are no machine learning filtering systems in the pipeline, at least that I know of, but that they're reliable. And I'm happy to argue why I don't think there will be a great solution, at least in the foreseeable future here. That means that the approach that some countries are taking of dealing with this problem is the following. They're saying, okay, we have to allow preventive measures and we only have filtering technology on the market. So let's just say, admit implicitly that filters cannot deal with exceptions and say it's enough to have a complaint and redress mechanism under Article 17.9. Well, I think that type of interpretation is actually not compliant, not only with Article 17.7 and the freedom of expression concerns that underpin it, but it's inconsistent with the capabilities of the filters themselves. It's inconsistent with empirical evidence that exists that says that counter notices are not really used a lot by users. And Article 17.7 is very clear in saying that these user rights, I'm going to call them that, and freedoms shall not be prevented, shall not be avoided, let's call it, by the implementation of the preventive measures in Article 17.4. And of course, there's also the issue of proportionality. Other alternatives exist. So this type of legal interpretation some countries are using is not, in my view, admissible. Now, if it's not admissible because actually user rights are at a higher hierarchical level normatively than these preventive measures, what's the solution? Now, together with a lot of academics, we came, don't worry about reading this, probably you get myopia just from reading this slide, but we've come up with the possibility of trying to interpret in a friendly way, fundamental rights and user rights friendly way, these provisions. And what we come up with, and this is the important part here, and I'm gonna pump it up a little bit here, is this idea that beyond one-to-one matches, where what's uploaded is a movie, for example, and beyond the equivalent files, and this comes from a recent Facebook Austria case that says that if something in the defamation context, something is near equivalent, or is equivalent or near identical to a pre-existing item that was taken down, then you can impose automated measures for this, especially in a notice and stay down context. We argue that unless this is the case, if you're playing with content recognition technologies, if you're using them, you don't have to use them, but if you're using them, then if you come up only with a partial match, you should be able to tell the user when it's uploading, allow him to flag whether they're making a lawful use covered by one of these user rights. And if they flag this lawful use, let me go back, then actually the content stays up. So all of this is taken up on the upload, and then obviously the rights holder can try to object to it. There's complaint and redress mechanisms, but this would be the basic logic. What I also argue, and this is not in the declaration, but my particular opinion is that unless this partial match is very close to the equivalent file, so a high level partial match based on high industry standards of the technology, you actually should go to a notice and take down system, because below that threshold, there shouldn't be a presumption that this is infringement. There should be a presumption that this is actually content that should be uploaded, and then you already have to have, let me go back to it, an expeditious and effective complaint and redress mechanism. So in that case, rights holders would have an opportunity to use such a mechanism. So I think this would be the most consistent and user rights friendly interpretation. I'm open to others. I think what we cannot have, in my view, is this situation where you just block everything that you want to block and then ask users, when you know that users don't use it properly, and it's sometimes opaque systems, to have complaint and redress. And I'm going to end on that. So thank you very much for staying with me. I hope it was around 40 minutes, and I'm very happy to take any questions you might have and also to see your faces. So I'm going to stop sharing now, Seth, if you're okay with that.
You can stop sharing your slides, but you do have to continue to share your opinions with us when we get the questions. And thank you so much for that tour de force, and quite interesting takes, novel takes, and very well-informed takes on Article 17 and the potential implementations. I'm very curious to see what the questions we have. For those of you who may have popped in late, I agree that it's a great presentation. Please submit your questions via the chat function, and I'll go ahead and read them aloud. I love reading questions aloud. If you've ever played Trivial Pursuit with me, you'll know that that's one of my peculiarities. And if you don't have questions, which I'm sure you do, I have a few of my own. So while you're typing them out, I'm going to ask you a question, João. I have tons of questions. I'm going to go straight to one that I think might be the most financially interesting, which is the definitional question of OCSSP, who's in, who's out. And if I understand correctly, the content ordering or centralized content ordering done by YouTube with regard to the content that they have would differentiate this YouTube from Facebook, which is more of a a feed based on my friends. I would say it's true that when you go to YouTube, you see a selection of videos. You can do a search function. It's got a different user interface. That's for sure. But both are driven by algorithms, yeah, at the foundation. And I'm wondering if the algorithm coupled with my selection, pre-selection of friends, isn't some sort of type of decentralized ordering, which may even be superior to the algorithm put in place by YouTube, based, of course, on my selections and my account and on those things. So yes, it looks very different, right? But I don't know.
I like the question, and I think I already see that we have a few others. Well, my answer would be, this is not necessarily my opinion. I want to make, but when I read it, I think there is merit to that. And I actually think there is merit to exploring the definition of these platforms, because it says actually in recital 63, if I'm not mistaken, that this should be evaluated on a case-by-case basis, which is quite surprising for a law, that you in a recital immediately say that this not clearly applies to everyone, but it's case-by-case basis. But I think the argument goes as follows, if I can make justice to it. The argument is, look, there are certain elements in the positive, as I call it, the positive definition of online content sharing service provider, that indicate that a key element of it is that it must organize and promote. Now, depending, and this was thought of, really, this was designed on basis of existing case law on Article 14 of the E-Commerce Directive. But the idea here is that if you are strict with that requirement, what does it mean for social networks that do not have this kind of specific oriented aggregation towards this type of service? And this is the argument. Now, you can argue, okay, but they have some sort of algorithmic organization that in the end allows you some structure of common. This is true, but I think the intention here towards a specific aim that then links with the aim of competing, or the effect of competing, is quite important. Now, having said that, I do want to point out that if you do go on Facebook and you do this experiment of putting an hashtag of a photographer, and the lady from the CMO in the Netherlands, Pictorite, did that last Friday, it shows something quite similar to aggregated content. So it is a difficult argument to pass, but I think there is some merit in that, especially if you go then lower down the level to smaller, less sophisticated social networks or websites that mostly are doing hosting of content for primarily other aims without such a level of sophistication. So I think this is quite important, and national lawmakers are really just not taking that position, and the stakeholders dialogue will not be important in that respect. I don't think it will be determinative in that respect. So I do assume that unless the bigger platforms go ahead and say, okay, I consider myself under it, and I pay, and I don't know if anyone from Facebook is here today, but that would be interesting to know, then this is going to go to court, and I'm interested to see how the court is going to react to that, because then what the court will have to do, if it goes up to CGU, is actually to put some meat on the bones of that definition and drawing a little bit of where do you draw the line for this. So it's a long answer, I apologize.
It was a longer question. I do think if it does fall into the definition, you're going to have issues for the redress measures, because those become much more problematic when content is taken down on the social media platforms, right? That's where the user rights need to be protected.
It is a good point, but also on video sharing platforms is quite problematic, I think.
Yeah, for sure. Okay, I'm going to get to the questions. I'm going to just go in order. We have a question from Sebastian, who has unfortunately not read the working paper. I believe that's the WP. How do you overcome the reference to Article 3, 1, and 2 InfoSoc in Recital 64?
Well, I don't think it's actually so problematic, because even in the provision, the specific mention to Article 3 of the InfoSoc, we're talking about the paper with Martin, right? It actually refers to the user upload directly and uses the reference only to identify the category of rights holders. So it's a shorthand for the list in Article 3. I think so in that sense, well, let me be very clear here. The Article 17 has a clear preference for an implementation as an exclusive right. And there's another recital which talks about freedom of contract, that's very clear. Our point is merely that that is not stated explicitly in the provision cannot be derived directly from the recitals. And then as such, you have to look at the beast itself, so the monster, as Severin calls it. And if the monster is such that it doesn't fit the pre-existing reality, which we think is the case, then you have to draw some conclusions from it. And I think the conclusion we draw is, this is not clearly a right under Article 3. And depending on how you read the interpretation of the Court of Justice of Article 3, and it's like, the time I wrote an article on it, it was we were at up to 30, I think, or 26 cases, it's more now. If you read that, it doesn't fit clearly into that definition. And then that allows you to play a little bit around. But that also depends, in my view, on how we interpret the nature of the connection to the non-commercial user upload. Is it a constitutive part of the right or not? How we interpret whether mechanism in Article 4 is a constitutive element of the right, or is something separate, like an enforcement limitation. And depending on how you interpret those modules, then you're gonna have different legal consequences. From our point of view, how we're interpreting, we don't think that, even if you would consider it under Article 3, it has to at least be a special right, because it has certain clusters of connections in the right that do not allow another interpretation. My opinion, I want to be clear on this.
Okay, next question. How do you think it will interact? This is from Ruth Flaherty. How do you think it will interact with the UK's regime? Given the UK campaigned for the DSM directive, then has stated they will not implement the directive.
Yeah, that's a really tricky one. You know, Lionel Bentley was at the IVIR a while back doing a talk on Brexit and IP, and we were discussing the very complicated legal provisions on that. Well, I think it's going to be very complicated. So I think the easiest thing is, if this is implemented under Article 3, you deal with this with licensing, and if you have collective licensing for certain types of works, PRS will come in as part of a reciprocal representation agreement representing the repertoire in the UK. But I think I would not want to be the lawyer drafting up these agreements, because it just doesn't match. And of course, we also know that the UK, the last version of the bill that I know says this weird provision that says it takes up the existing acquis, but it can decide at any time to deviate from it under a special regulation system. I don't know if I'm being correct about this. And so we even don't know if a choice is made later on by the legislature in the UK to further carve out from Article 17. So I'm sorry, I can't give you a satisfactory answer. I just think it's going to be a mess. Okay, hopefully. And thank you for the question, of course, Ruth. Yes. So Dean Marks, a member of the MIPLC faculty who just completed his course on IP in the creative industries, asks, how do you think Content ID has worked in practice on YouTube? Has it resulted in lots of false positives and other problems you identified? So this is a really tricky question, right? We have, for the most part, anecdata, not real data on it. But what we do have now for studies that are more serious out there, there is some effect on it. Now, the problem is the following. It's a counterfactual that's difficult to prove. We have numbers that say not a lot of users appeal in a complaint and redress. So the counter notice procedure, now you can interpret it both ways. Then you interpret it's working really well. Users understand that the thing was blocked for a good reason. Or you can take the more reasonable approach and actually think, well, it's too cumbersome for users to actually go through such a process. So of course, you can also have to take into consideration that a lot of content is then subsequently monetized. That's a positive thing, in a sense that you then have a licensing system within the platform that is part or an extension of Content ID. But this is a little bit tricky for me to accept easily, because sometimes you're licensing content and monetizing that you are not entitled to as the rights holder, and you're blocking content that you're not entitled to as the platform. So this comes back to our normative preferences. Do I want to be in a system that has this so-called, let me use the term, chilling effects here, or not? And I'm not comfortable in that system, so I have to say, although the Content ID works as well as it probably can with the current incentives on the market, I don't have enough data to tell you whether it works really, really well. And it's one system that has cost millions and millions of euros or dollars to develop. So what are we going to license it downstream to other players? Are third-party providers giving their own system? So the whole thing is, in the end, let me just add this. It is very clear. For example, Gemma already had a licensing deal resulting from years of judicial procedures in Germany. with YouTube. So in fact, this provision is quite honestly more of a way, a broad sword under which to negotiate a better agreement on better terms than actually an argument for a reason for getting an agreement. The agreement is already there, or was already there.
Thanks. Question from Olaf. Regarding who, what is affected, Article 17 seems to focus on uploaded and stored content. What about ephemeral content, given the trend towards live streaming, broadcasting, etc.?
Yeah, I know that Eleonora has written a paper on that. I unfortunately only have browsed through it. I have doubts, and I have the same doubts that whether it applies also on the basis of the recital that excludes piracy websites from the benefit of the liability exemption mechanism. So there's a mouthful of words to say the following. There's a recital in the directive that says, it's poorly written, but what it means, I think the right interpretation is the following. It means that piracy websites are covered, they are OCSSPs, but national legislators are free or actually incentivized to exclude them from the benefit of a liability exemption mechanism. The logic being, we're going to bring them into this regime, but we're not going to give them the possibility to get a liability exemption under 17.4. Not that I think they would want to. Now, already last June, when we did a conference on this, my argument was like, what happens with BitTorrent websites? What happens with websites that don't actually host content? I'm not, under the letter of the law, I'm sorry to say these are not covered. Now, this will have to go to the court, and the court will have to do an extensive interpretation of the concept, which it has done for Article 3 before, and we'll have to cover them. Now, if you think the right is already under Article 3, you can actually do some sort of legal jiu-jitsu to say that it covers those. But if you read the law, and methods of legal interpretation one-on-one is literal interpretation comes first, it does not seem to me that hosting necessarily means more than hosting. So Olaf, to your question, thank you. I think it can, and it might, and if it goes to court, it probably will. Not convinced that under the current letter of the law, it actually does automatically.
Okay, next question from Alan. Is there a path in the directive for suing YouTube for taking down a legally permitted use such as a parody?
Oof, yeah, this is a, thank you, Alain. I have a lot to do. I'm assuming this is Alain Rocha Souza.
It is.
Brazilian friend. So there is a path, and I think this is one of the problems, right? In this proposal that we advanced, the underlying assumption is, look, right now the incentive is very clear for the platform. If you implement the Dutch way, the way I explained in the slide, you're going to take down more than you need. The default is going to be taking down content because you don't want to be liable as a platform. Now, you might be liable before users, but you had then to consider that this is indeed a user right, so that it gives you active legitimacy to pursue a case, or that at least a representative of the user, I've suggested consumer organizations or NGOs, could actually do that. Now, what we suggested in the academic recommendation is something a bit more balanced, which is saying we have to incentivize the platforms that have a lot of obligations under this regime to balance the regime out, to actually try to use content recognition technologies in the system to allow content that's lawful use to stay up. And if we do that, a good faith platform that complies with the process is within a notice and action procedure. And for the course of that notice and action procedure, they should not be liable if they're complying with their legal obligations. So yeah, the path is there. A good interpretation would limit that path by incentivizing platforms to take user rights into account.
Okay, we've got a question here from Martin Happel, and I think it relates a little bit to my first question. Would you consider users organizing content using titles or hashtags as organizing under Article 17? Also, Facebook has the watch module which organizes media, so I don't think that Facebook can be excluded. So that's going back to...
Yeah, indeed. So I think one of the issues here is, are we talking about the whole platform or the services of the platform? And this is a problem I have with this provision, and we can discuss it for hours. Hosting service providers, as I see it in the pre-existing world, we're mostly assessing on a case-by-case basis specific services provided by the platform and deciding whether that service, whether the platform has liability or liability attaches on the basis of a specific service. Now, these are multi-purpose platforms that have different services. Like YouTube also has a Spotify-like service in vivo that clearly has to be licensed. What we're talking about is the purely user-generated content one. So outside of Facebook Watch is the other construction for that construction, qualifying them as an OCSSP for those purposes. And as a legislator in a court, I would look at it this way. Although we talk about OCSSPs as the object of regulation, I think we always have to assess their services. So it might be the case that a good interpretation would say for some services, Facebook is an OCSSP, for others, it is not. Now, the law doesn't really help with that because it's not really clearly written, but that's how I would read it. To the first question of, I think, Martin, I would say no. I don't think so, unless the users present themselves as an hosting service provider of some sort. I think I would say no, but it depends on the case, right? If you have a Wikipedia-like situation and then clearly the structure of the hashtags goes to a point where it's everything clearly organized, and yeah, even then depends on are they for profit or not? Are they more of a Wikipedia or not? So not a clear answer that, but on the basis of the description in the question, I would say no, in my view.
Thank you. Moving to Sunima's question. Sunima Mendes, class of 8-9, Sunima, I believe. Yes, got it right. Fantastic. Just curious to know your take on the exceptions in Article 17.7, which states that member states shall ensure that users in each member state shall ensure that users are able to rely on any of the following existing exceptions or limitations. Do you think this wording could be interpreted to mean that these exceptions and limitations are now converted or covered to positive user rights that are capable of being enforced?
Well, thank you, Sunil. That's a great question. So my opinion, not the opinion of the executive committee of the LIE, my opinion is yes. And I think, but it's not immediately written in, but I think you have to go a bit deeper there. You have to go to the latest Grain-Shaber trilogy of the Court of Justice, Funke Medium, Pelham, oh God, I'm missing the Afghanistan papers. Okay. And Spiegel Online. I think that's it. Okay. You know, the trick is you have to look at those and how they interpreted some of these provisions based on already the case law in Painter and others. And unfortunately, not the case law in private copying. It's a pet peeve of mine because they forget to recognize that private copying as a fundamental rights privacy limitation. But stepping that aside, what the court has been constantly saying, consistently, and now these cases say it very clearly, and also you can look at UPC Telecabo, is that we have internal mechanisms, exceptions are the internal mechanisms that corporize or actualize fundamental rights within the system. By doing so, and this is actually outside the case law of copyright, people accept it easily. This is the Maloney doctrine goes in that direction, right? If you don't have a fundamental right that directly applies, there's a legal provision within the system that would, let's do the dirty work of the fundamental right for it. And what the court has always said is that in these cases, the exception scope expands. Already when I wrote my thesis and my book, this was the case. In these three cases, very clear. The court goes even so far in one of the cases saying they become user rights. Now, of course, the provision does not say subjective rights, but I think this interpretation is clear. And if you now look at the exceptions in 17.7, they are different. I've called them different beasts. Why? Because they are mandatory. In my view, not subject to contractual override or override by technical protection measures. So they not only follow on this logic, but they extend on it because they have a reinforced legal protection. So if that is the case, I don't see a world where these cannot give a cause of action. These cannot be considered akin to subjective rights. Now, of course, many people will argue about this, but I think whatever you call them in the academic declaration, we ended up calling them user rights or freedoms to accommodate different opinions. But what everyone recognizes, even if not a label, is the nature. These have a reinforced nature. And if the court has already interpreted exceptions that are comparatively minor because they're optional, even in a certain strong way that is almost as a user right, by bringing fundamental rights explicitly into them, these exceptions that are explicitly in 17.7 based on fundamental rights as per her recital on freedom of expression and the arts, I don't see how you can argue otherwise reasonably, right? Of course, if I had to argue for the other side, I could argue it, but I don't think that's a serious argument. Now, the consequences from not being called subjective rights are different, right? Because under different national laws, it might be then easier to put them under the umbrella of subjective rights and give a cause of action. But as a matter of European law, I think, you know, it's difficult not to go there, I would say. So that's, again, my opinion. This is not consensual.
Thank you.
I always have to make this disclaimer.
I'm going to watch the clock for your child. And I'm just going to say right now, probably not worthwhile at this point to submit too many more questions because I'm not sure we're going to get to the ones that we already have on the board here. I apologize, but we just do have a finite amount of time.
I'll do my best. I'll do my
You'll
best.
do his best. Okay. It's the lightning round. We have a question here from Bulis Mate. If I don't get your name pronounced right, I apologize. Who is appreciative of the presentation for sure and has what he or she terms a simple question. Wants to know whether this IP law has been adopted by all EU member states or in the directive implementation. What's the phase? Could you give us the status?
Yeah, so the status, I went briefly through it, is we had these mandated stakeholder agreements that the Commission was forced to organize. So what the Commission has done is put 60 to 70 people in a room and have a sort of shouting match saying, this is what I think this means, this is what. Then some companies come in, YouTube shows how their system works, Facebook shows how their system works, nice slides without a lot of information. Some important stuff comes out. At the end of it, the Commission has to come with some guidelines. And Marco Gerello, the head of the copyright units, told in a panel that we were at last week that they should come out later this week or early next week for public consultation. Then the stakeholders will comment on them, and then the Commission will come out and say, for certain of these provisions, especially this relationship between preventive measures, user rights, and safeguards, we think this is the best possible interpretation. Now, it was clear to me, I might be disappointed later on, that if they view within the Commission that Article 7 and 9 are different provisions and they have to be treated as such, which means that the Dutch implementation and others, the French one I think too, would not be viable as per the stakeholder outcome. But you know, things change so quickly in the copyright debate that I don't know. And then national implementations by June, I think, 2021, if I'm not mistaken. And right now we are aware of 6 or 7 proposals that are public, and I'm aware of a few more that are on the back burner, like in Germany. In Germany, they've had a proposal ready for a while, I think. I've heard through the grapevine, but you know, politics. So.
Okay, next question from Zebra Guzel. We have, isn't the preventative filtering of the Article 17.4 requiring monitoring that observes all files stored for an unlimited period of time and resulting in a conflict with the Article 15.1 of the e-commerce? And how can this conflict be avoided with a different implementation by a member state?
Well, actually the answer, Seba, thank you for the question, is simpler than that. So the provision is lex specialis to the e-commerce directive. There's a carve out. There's also a carve out to the obligation of general monitoring in Article 15. And I believe it's in Article 17.8. They repeat more or less there won't be general monitoring within the scheme of the directive. In my view, what this is going to end up with is we're going to have 2 different bands of general monitoring with probably different scopes. The prevailing view following the court's case law on Article 15 of the e-commerce directive has been that if you are monitoring everything that comes in, but for specific files for which rights holders gave you information, this is not general monitoring, it's specific monitoring. It really depends on what you see. Obviously, you're monitoring everything, but you're monitoring for specific metadata information given. We can be playing around with words, whether this is general or specific, but this is where we are at now, and this is clearly what Article 17 kind of allows. So I think what we're going to have, unfortunately, is a weaker ban on general monitoring in the copyright directive. Having said that, we are now coming roundabout to reviewing the e-commerce directive in the Digital Services Act. And as those of you know, some of them have read the public consultation and have read the documents, you know, that's very much on the cards, a change on the general monitoring obligation in some way, shape, or form. So it might be that we end up with something worse than we had before. I'm not a big fan of that idea. I think this is a pillar that has worked quite well, but I don't make law. I just comment on it. So, yeah.
Okay. Maybe 3 or 4 more questions, Charles? Let me know.
Sure.
Okay.
I think baby M has stopped crying. So
nice. Okay,
hopefully.
fantastic. We'll have question from Alvaro. We have, do you think it would be in accordance with the directive to make licensing for the purposes of Article 17 compulsory, subject to collective management? In other words,
sorry, go ahead.
No, in other words, can a member state in transposition defer licensing exclusively to collecting societies?
So, well, despite my interpretation in Martin's article, I think that possibility is available in some cases. Now, what you have to understand is mandatory licensing, well, the baseline that we have is what the directive calls collective licensing with extended effect in Article 12, which includes the traditional ECL, extended collective licensing, but also legal presumptions and mandates. So it's a big of a broader scope. That's the baseline. That baseline, fortunately, now has put to rest the idea that ECL is an exception and limitation, which in my view was never correct. But in any case, it's basically established as a baseline. That provision already has a number of strict requirements. That means that even in our interpretation, it's logical that you would have to have specific market conditions and specific requirements on the field for these types of mechanisms to be implemented. Now, I happen to think that if you have an obligation to license everything that's uploaded on your platform, unless you're very cautious and generous in the best efforts interpretation, that's in Article 17.4, that you have actually then a condition in a lot of fields for a lot of types of contents to impose such a regime, if you agree with Martin and mine's interpretation. If you don't agree with that, then you don't have that space. And then you have to think about other solutions, direct licensing, some model of voluntary collective licensing with reciprocal representations agreements, or collective licensing with extended effect that are not pan-European solutions. You can think of some pan-European solutions based on collective management, but I don't think they will have the type of exposure and coverage in terms of blanket licensing that's required by the provision, unless we are very generous in interpreting what you actually have to license by looking at the definition of OCSSP and saying, I only have to license the main stuff for that type of content in which the platform has an actual competitive effect on the market. That changes the equation altogether. But this is not what a lot of national laws are going for. So a roundabout way of saying, in some cases, yes, or one size does not fit all in this case for anything. So yes and no.
Okay, well, we've got some discussion going on in the comments as well, and some exchange of views and links, which is great to see. We have a question here from Sebastian Post about if you read an obligation, any obligation for right holders to make best efforts to provide easy access to accurate metadata and rights management or licensing information for OCSSPs to obtain authorization.
Thank you for the question, Sebastian. I think it is very clear in the provision that you have to provide high-level information. So I don't think you can, there are some interpretations out there that say one of the ways to look at proportionality is actually on the rights holder side, just to give very low-level information, and the platform just acts on that low-level information. I think this is a recipe for filtering disaster. So I'm very opposed to that. I think the provision clearly establishes a threshold that we have to look at existing law on UPC Telecable, MAFADA no, but UPC Telecable and others that talk about the type of information and the type of notices that you have to provide. And I think in this case, the stakeholder agreement would be very useful to say, what's the type of high-level information or detailed information, actually, I mean, that you need to provide. So I think that obligation is clearly there. Now, they're obliged to provide that to the OCSSPs. What would be useful is to create a way, either on the rights holder side, which I think is easiest, or on the platform side, which I think is harder, to create actually standardized metadata for this. But this is a problem that we've been discussing. Largely a lot of literature on the blockchain area, intersection with copyright talks about this. But we've been talking about this in the licensing debate for a long, long time. The incentives are still not there yet. So unfortunately, I think this is the situation we are at, but I think that obligation is there. Definitely. How it gets interpreted is it's a different mechanism. I just want to add the following thing. We have to be aware that all these content recognition systems are different. They rely on the same logic of matching, which is why it's a problem for context, but some of them are fingerprints, some of them are hashes, others are different. So these are already the high industry standards, so to speak, that's on the market. You cannot oblige OCSSPs to change all their business models. So that's why I say it perhaps makes more sense on the rights holder side to harmonize the metadata according to some of the codes that already exist there. And then it's easier for an OSSP to actually access that database and match it to its own. But this is already a second and third degree interpretation.
Okay. Last question from Anna Lazarova. would you comment on paragraph 2, licensing agreements covering acts carried out by users of the services in terms of potential collective licensing of synchronization rights? My impression is that for the most part, UGC, for example, bidding, compilations, personal family, etc., even non-commercial ones would be such that require a synchronization license. I'm not aware of any research showing what is the predominant user behavior when posting on a OCSSP platform. And we know that CMOs usually cannot grant sync licenses on a collective basis.
Yeah, this is a super interesting lawyery question. I would say it's nice. So assuming that the synchronization license, for those that are not fully familiar with the reality, if I'm explaining well, is usually when you match a certain protected item like a song to a certain video or something. So, and you adapt it to that reality. You see it a lot on commercials, for example. And here, the argument, I guess, would be something of the sort. Well, a lot of this is like sync. Well, problem number one, a lot of sync licenses under national law might be covered partially by the non-harmonized right of adaptation. But let's put that aside for now, because the reproduction right is so broad. I don't think under Article 17 you could do that, for the simple reason that the uses that we're calling these non-commercial uses are really structured in a way of, clearly in that case, reproduction, especially communication to the public under the InfoSoc directive. So the idea behind that is that what we want to do is enable the platform to communicate this to a public for a price. So whatever sync is involved in that is priced into the license or authorization that you obtain. Now, you might say this is an imperfect legal construct for the particular reality of some non-commercial user uploads, perhaps, but I think I would say Article 17 cuts directly through that like a hot knife on butter and just says this is the solution. And only if the user gets out of the threshold of non-commerciality or doesn't have significant revenues, can you then go to the user and say, okay, for these users, if you want to monetize, and then you have to talk to the platform, can I get a sync license? But even then you're in trouble because a platform has already obtained an authorization for uploading that particular work. So the license can only be obtained by the user and it's not non-commercial anymore. So I don't know if it's a fully satisfactory answer, but it's what I can provide. I think I can get one or two more if there exists sets, and then we.
There's
not to be unfair, there's such interesting questions. So
there's discussions going on about who, for example, there's a comment that according to Article 17, I think the winner, who's going to win at the end, may be the tech companies like Audible Magic.
Yeah, I think this is it's a valid comment. The competition law angle has been mentioned in a way, in a sense. Who has if you go for an implementation that presupposes filtering technology to be available, you have to get that technology. Most companies cannot get that technology. So if you don't create a best efforts obligation that doesn't mandate them to get that technology, they have an obligation to obtain it. How do they obtain it? They have to obtain it either through a license from a major major platform that has it, downstream licensing, so another market for big platforms, or to a third-party vendor like Audible or PEX. PEX is a really strong one on the market right now. Yeah, but this is what we do with cloud services and with other realities. And yeah, unfortunately, yes, it's a risk. It's a risk.
It kind of goes to a question that I have, or a tendency that you see in this maybe 20, 25 years, 30 years after the advent of internet technology and the real discussion about digitization and copyright, where you see at the beginning, you would have these content platform technology sharing companies on the same side, more or less, with their aligned with users.
Yeah.
And here you have well-established OC SSPs, YouTube being one of them, basically Google, right? And in the discussions, they're not being quite an advocate for user rights that they may have once been, right?
Yeah,
they seem to be set with the legal regime. They have filtering technologies. They may even be able to license out their filtering technology, maybe even a legal obligation almost. They're going to have some % of the market share for sure. And I find it striking that the comments surrounding the DMCA, notice and takedown, and the similar comments taking place in Europe are always about the lack of procedural due process for users' rights. And you see here, and you see it being introduced when revisiting the e-commerce directive, we're going even further away from procedural protections of users' rights, unless you were to implement your suggestion about the flagging and it just stays up. And I'd like to hear your thoughts on that.
Yeah, I think this is maybe a nice way to end it. Well, I think for one, the market reality has become much more sophisticated and once with this shift to so-called Web 2.0. So these are different types of platforms than the ones that existed before, and they are seriously entrenched in the market in the way that some of the others were not at the time, or at least they had a different perception of what the market was. I think what we read about a lot of these considerations in academia, it's really important to note that, because when I go to some of these debates with rights holders, I'm sometimes surprised by how little they read of views that are not within the so-called filter bubble, no pun intended, or slightly, or echo chamber. And so I think the academic debate takes this very seriously into consideration. And I think NGOs have been more sophisticated in bringing this, or user rights groups or digital activists, in bringing this to the forefront of the discussion. But if you go to Brussels, you don't see that so much. You see that as a small part of the debate, and you see these players dealing with the reality they have. And the reality they have is they have a very strong opponent in incumbent legacy content industries that is very entrenched in the political sphere. And this is the battle they're trying to fight. And their interests are not always aligned with users. Like, to use the case of YouTube, I have nothing particular, but YouTube can comply easily with this provision. They will pay more money and license the works in a different way, probably, but they will have no difficulty meeting the obligations in this provision. So I don't think, if from a business perspective, does it really make sense to change a lot of my system to satisfy the interests of users if I can already comply with it? So I think I understand from their point of view, they're trying to weigh these things. Do I fundamentally change this and open up a war with the players that are really strong, or not? Or do I do the right thing? Or not doing so would be the right thing, I think, in this case. So it's quite, there's a lot of different policy levers here and motivations that are in play. And I think it's just a much more complicated world right now than it was before. So.
Thank you. Well, we'll just wrap it up there. And I'd really, the comments section is just really filling up with thank you for the excellent talk. Thank you so much.
Well, thank you so much for the excellent questions and for staying up so late.
Yeah, thank you, everybody. Thank you, everybody, for coming out. We really appreciate it. Really appreciate João taking his time. We will have further talks in the lecture series this summer, and we will be announcing them via our various social media channels, our website as well. And we hope that many of you can attend. We hope you had a great time, and we'll hope you come back.